Happy Tuesday! And welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about Indigenous rights and protests. Cases that should have gone to the Supreme Court of Canada, but didn't. In British Columbia, a number of people have been convicted for contempt of court on the basis of their involvement in anti-logging protests. One of those individuals, a member of a British Columbia First Nation, argued that they had the right to participate in these protests and defy the court order, and that should be taken into account in light of their Indigenous heritage in their sentencing. Essentially, not just Gladue principles should be taken into account, but the need for reconciliation with Indigenous communities and respecting the views of Indigenous communities and members of Indigenous communities when it comes to sentencing matters before the court. And that individuals who are of Indigenous heritage, who are participating in protests for reasons related to their heritage and protecting their traditional territory, should have that taken into account in reducing their level of moral blameworthiness on sentencing, and have that as a factor that ought to be considered by the sentencing judge. Very clearly, this case raises significant and important issues about the role that our courts play in engaging with Indigenous communities, particularly when it comes to offenses that are really state offenses. When we're dealing with Indigenous offenders, we're often dealing with people who end up before the courts for the Gladue principle reasons related to the impacts of colonialism. But these cases involving contempt of court and protests deal with it in a different way. It's not the impacts of colonialism that has led them to be in the position that they're before the courts, so much as it is the ongoing effects of colonialism that have led to resistance. And with resistance comes resilience. And with resilience comes the need for the state to reconcile with Indigenous communities, which is not being done when Indigenous people are being prosecuted for offenses involving protesting actions of the state that they view as colonial oppression of their communities and of their territories. And it's unfortunate that the Supreme Court of Canada didn't really hone in on the real important issues that affect the obligations that the government and the courts owe to Indigenous perspectives, particularly where it plays a role in the actual commission of the offense, but not in the way that the courts have repeatedly recognized under the Gladue factors that are codified in the criminal code. This was an opportunity for the Supreme Court of Canada not to authorize protest activity that violates court orders, but at least to create a sentencing structure that recognizes the practical realities of who is doing the protesting and who is more likely to have court orders enforced against them for reasons that strike to the core of their personal beliefs and their sense of self. And unfortunately, the Supreme Court of Canada really missed the mark by not taking on this case, which raises incredibly important issues that affect everybody across this country as we deal with the need to protect our precious resources. Hopefully, the Supreme Court of Canada has another opportunity to look at the different ways in which Indigenous heritage and culture and reconciliation can be respected in our court process before it's too late. Thank you. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.